On the final day of Amy Coney Barrett's Supreme Court confirmation hearings, Senator Richard Blumenthal asked a question that may have left some viewers scratching their heads.
Are you aware of the Supreme Court, as it's called, Shadow Docket?
I am.
The Shadow Docket sounds like a 1930s radio drama about a mysterious lawyer.
Who knows what evil lurks in the hearts of men?
But actually, it's a relatively new name for one way the Supreme Court does business. And it's been getting a lot of attention lately.
There's been a lot of shadow docket activity over the course of the last term.
Late tonight, the U.S. Supreme Court ruled churches in California can hold indoor services during the pandemic.
A major decision by the Supreme Court blocking the Biden administration's temporary ban on eviction.
A deeply divided Supreme Court is allowing a Texas law that bans most abortions to remain in force.
The decision came in the dead of night with virtually no explanation.
Hi, my name is Jordan Rubin. Wait, could we actually get some lights on in here? Thank you. My name is Jordan Rubin, and I cover the Supreme Court for Bloomberg Law.
We asked Jordan to shed some light on the Shadow Docket. But first, let's look at how the Supreme Court operates. Work at the court is divided into two main categories. The first is by way of the merits docket. That consists of the cases the court hears in person, starting the first Monday in October. On average, over the last decade, that's been about 76 cases each term.
When we think of the Supreme Court, we think of the 9 Supreme Court justices in their black robes, hearing oral arguments, and then eventually signing on to a decision in the case, all signing their names to how each justice voted. But there's a whole nother area where the court does business, and that's what's called the Shadow Docket.
The Shadow Docket has a real, less ominous-sounding name, the Orders Docket. It's the way the court handles the thousands of cases we don't see on the news. Things like refusing to hear a case, denying emergency relief when there's no true emergency, ruling on whether to delay an execution, and clearing up routine procedural matters. By tradition, cases on the Orders Docket receive no oral arguments, and the justices give little explanation for their decisions. Because many of those decisions are uncontroversial, they often receive little attention. But in recent years, the court has been using a subset of the Orders Docket, the part that deals with emergency applications, to issue more and more noteworthy rulings in important cases. Hence the shadowy nickname, which was coined in 2015 by University of Chicago law professor William Bode.
What we're really seeing an uptick in is applications for emergency relief, where the parties are asking the justices to change the status quo as the case works its way through the courts.
Steve Vladeck is a professor at the University of Texas School of Law. He's testified before Congress twice on the court's increasing use of the Shadow Docket.
These interventions directly affect us. Federal programs in response to COVID, how we vote, all of these things being addressed through these orders that by tradition are not signed, that by tradition are not explained, and yet that by increasing practice are directly affecting millions of Americans when they're issued.
Take the court's decision to keep in place a controversial Texas law banning abortions after 6 weeks. The court took 3 days to consider the order and issued a 1-paragraph unsigned decision delivered just before midnight. In her dissent, Justice Elena Kagan wrote, "The majority's decision is emblematic of too much of this court's shadow docket decision-making, which every day becomes more unreasoned, inconsistent, and impossible to defend." Of course, concern among justices about the shadow docket is not unanimous. Samuel Alito dismissed criticism as coming from people unhappy about decisions that haven't gone their way. Love it or hate it, there's no debate that the court's use of the shadow docket is growing. So the question is, why?
I think there are a couple of different sources for the uptick. I mean, I think one, red states like my state of Texas challenging every Biden administration policy they can get their hands on.
It's a trend that started during Donald Trump's administration. As lower courts struck down many of his executive orders, President Trump's Solicitor General appealed to the Supreme Court via the shadow docket a record 41 times. The court reversed 28 of those lower court decisions. Vladeck says a noticeable surge in the court's usage of the shadow docket came after Brett Kavanaugh replaced reliable swing vote Anthony Kennedy in 2018, and again in 2020 when Amy Coney Barrett replaced Ruth Bader Ginsburg.
It shouldn't surprise anyone that it's a lot easier to sign on to an unsigned order where you're endorsing precisely zero analysis, than to join in a 65-page majority opinion that carefully works through 7 different constitutional questions.
So what's to be done? Eliminating the ability to apply for emergency relief isn't the answer. Courts need a way to quickly respond to fast-moving developments. And lower courts seem increasingly willing to block politically sensitive government policies, so the court will continue to see plenty of hot-button issues.
One thing that's been talked about is forcing the justices, for example, to note how they voted. It's questionable, even if that's successful in Congress, whether the justices will see themselves bound by that or whether that's too much of an incursion on their power.
It should behoove all of us to have more explanation for these rulings, not less.
In the end, it will likely be up to the justices themselves to decide if they want to bring the shadow docket out of the shadows and into the light.